Welcome, welcome today to our next section. It's the same section that has to do with the course Introduction to the Criminal Justice System. The course will continue until we can exhaust the syllabus. And so for today, the last time we stopped on crime, and we told you that criminal justice, we gave you the basic definition of what criminal justice is. We told you specifically the phrases that make up the definition, and those phrases speak to particular areas relating to the criminal justice system. What we did last week was on the introduction, and then we broke the definition down into what is referred to as the nature of crime in society. We explained to you what is meant by the nature of crime in society. We went to the analysis of the formal processes, and we told you exactly what the formal processes are. That means that we are talking about the criminal procedural law, the criminal justice process, the criminal justice highway. From the day the crime was committed and there is an arrest effected by the police or law enforcement agency up to the point of charging, presentation in court, indictment, criminal trial. We explain all of that in this course as time goes by. But I'm just explaining to you the stages and the various phases. Then you go to appeal. When the appeal is affirmed in terms of the conviction, the person goes to prison and serve their term. And the purpose of sending them to prison is not really to incarcerate in particular, meaning to keep them in jail, but is to rehabilitate them, because the science of criminology shows that people commit crime because of three major factors that we talk about the nature of crime in society. So before the person is finally released, he becomes a productive citizen. And so he's rehabilitated. So that's the entire criminal justice process. That is what the court is all about. So today we try to reach to the point we try to talk about the area of crime. Last week I didn't deal with that sufficiently. And I told you what crime is all about. What is crime? How do you define crime? What is the meaning of crime in society? And then you see that crime is an act or omission in violation of the law. Whenever they say an omission or in violation of the law, simply they are telling you that any action that violates the law, the criminal law, technically in this definition is a crime. Also, your failure to act when the law requires you to act can constitute a crime. For example, if you are somewhere, you saw a child drowning in a pool, that you have the capacity to take that child out and you refuse to do so, and you stand up and you look at it happen. That's omission. Your failure to act. that constitutes a crime because the law imposes upon you certain obligations in that situation to act. An extension of omission sometimes you see is that when you fail to exercise certain care and duty that the law requires you to exercise, that also can constitute a crime. And then when you commit a crime, the law imposes punishment. And the punishment is in the form of fines, imprisonment, disqualification to hold office or disqualification from office, meaning they take you from office for violating the law. Those are all the punishments. So under our laws, no one should be punished when he had not been given due process of law. The due process of law, which is the law of the land, requires that before a person is punished, that person must commit a crime. And in order to establish that that person had committed a crime, you must accord them due process of law. When you hear they say due process of law, it means the law that can hear, the law that hears before it condemns. You can't say the person is accused of a crime and that person is not giving his day in court, and you conclude that the person is a criminal and must be treated as a criminal. Then you are violating the principle of the presumption of innocence. Let me say that again. The doctrine of the presumption of innocence. It says that a man is presumed innocent until he is proven guilty in a court of competent jurisdiction, meaning a court that has the authority to hear the case. That is what it means. I hope I'm not speeding up. I think this time I'm trying to be very slow, maybe for other persons who are not criminal justice practitioners, but have interest in the subject matter. The next stage is you can't define crime if you don't understand the elements of crime. Crimes have two elements, technically. For any criminal lawyer or inner criminal justice practitioner, crimes have two elements. Those elements must be present in order for a person to be guilty of a crime. Let me say that again. In order for the person to be held criminally responsible for his act, there are two elements that must be present. Those two elements are the act in itself must be defined by the penal law as a guilty act, or as a wrongful act, or as a criminal act. And that is what we call in criminal justice the actus reus. When you hear they say the actus reus, it means the guilty act. Actus reus is a Latin word. The guilty act. Those are Latin words that say that the act is defined by law as being guilty, as being wrong. In other words, no one can be accused of a crime when the act that he committed is not done voluntarily. You must act voluntarily, meaning you must act willfully with all your will. You must decide in your sound mind willingly to commit the act. The next element that must be present for any criminal act, for any act to be considered a criminal act, is called the mens rea. That is also referred to the Latin word, the guilty mind. No one is responsible for the criminal conduct if he did not have the intent to commit the act. So in criminal law and in the criminal justice system, in order for you to be guilty of a crime, the second element that must be present is the guilty mind, the intent to commit the crime. If you did not have the intent to commit the crime, then it is not a crime. That's what we call the mens rea, the guilty mind. So, there are instances where people commit crimes. For example, they carry out certain acts and the law says that this act is a criminal act. But if the act committed was not intentional, then it is not a crime. So the two elements must be present: the guilty act and the guilty mind. Before you are guilty of a crime, you must act, and that action must be defined by the penal law or the criminal law as a criminal act. And then when you committed that act, or when you carry out that act, you must plan it. You must plan it. You must deliberate. You must decide. You must willingly decide to do what you did. You must calculate your action. You must know the consequences of your actions. You must be well in the mind and the body. You must be somebody who was not sick at all. You can be an imbecile. In other words, somebody who has mental defects. A person with mental defects cannot be criminally responsible for their criminal conduct because they lacked the mens rea, meaning the guilty mind, to calculate, to understand the consequences of their actions. That is what it means. We'll let us go to the next slide. The types of crimes. The types of crime. From the criminal justice standpoint, we can categorize them as crime mala prohibita. Crime mala prohibita, those are crimes that we say they are evil, merely because they are prohibited by law. So long there is a statute, there is a law passed by the legislature defining a particular conduct to be the crime, then it is prohibited by statute. So it's called crime mala prohibita. That's the Latin. Another type, some of them you can see, we say what? They don't necessarily need to be crimes that are morally wrong or immoral, for example. But something like jaywalking is not a moral act, it's not an immoral act, but the law says that you can't jaywalk. And the question is, what is jaywalking? You left the sidewalk, you walk in the middle of the road, like jaywalking. You obstruct this flow of traffic. You run a red light. The red light is on, you run the light. You didn't wait. You didn't wait for the green light to come on. You ran. Those are crime mala prohibita. The next type of crime is crime mala insane. Or some they can say malum insane. Those are crimes that are evil in themselves. They are immorally wrong. In addition to the statute, in addition to the laws that have been passed or promulgated by the legislature as crimes. So we call them crime mala insane. Crimes that are wrong in themselves. Like what? Murder, arson, rape. These are crimes that are morally wrong. In addition to the promulgation of the law by the legislature, defining those acts to be crimes. So let me go over it. The types of crime. Mala prohibita and crime mala insane. Crime mala prohibita are crimes that are prohibited by law, by the statute. Crime mala prohibita. Also now you can say malum prohibitum. You can use it anyway. Those are Latin words. Then you get crime mala insane, or crime malum insane. Those are crimes that are wrong in themselves. They are evil in themselves. In addition to the laws that have been passed by the legislature defining them to be crimes. The next slide has to do with the classification of crimes. Under Liberian law, we have two classifications. We have misdemeanor, and then we have felony. Misdemeanor means crimes that are petty in nature. It means crimes where when you have committed them, you cannot spend your time in prison for more than a year. You can go to prison from 1 year downward, meaning less than a year. That's what we call misdemeanor, minor offenses. And most of the time, the punishment for these kind of crimes are usually fines. You get penalties, you get forfeiture, meaning you forego certain things because of the act you have committed, or they put you in confinement in a jail. Technically, in criminal justice, if you are guilty of a misdemeanor, you are not required to go to prison. You go to jail. Jail is a confinement facility that is used to incarcerate people who will serve lesser term, less than a year in jail, in incarceration. That's what we call jail. Jail is different from prison. As we go further, jail is different from prison. Prison is where they keep people who commit felonies from 1 year upward because they will be undergoing some rehabilitation programs. And they will be serving more than 1 year imprisonment. So you call that prison. So that is the difference between jail and prison. Prison, when we start to do corrections, you understand the different types of prisons. The different types. You have different types of prison. You have the solitary confinement, medium confinement, minimal confinement, and what have you. But we'll reach to that. That's not for this course. It's for corrections. Under Liberian law, you have misdemeanor of the first degree, and you have misdemeanor of the second degree. What does that mean? Under misdemeanor of the first degree, it means when you commit a crime, a misdemeanor of the first degree, you can go to jail and you can spend the time up to a year, but not more than a year in incarceration. You are not to go to jail for more than a year in incarceration when you commit first degree misdemeanor. Second degree misdemeanor is the kind of crime that when you commit, you cannot spend more than 30 days in prison. Like infraction, like DIU, driving, DWI, driving while intoxicated, or DUR, driving under the influence. Those kind of crimes, you go to say, let me go to jail, or vagrancy, let me go to jail for 30 days, or 15 days, or 1 week. Those are second degree misdemeanors. So there is a difference between misdemeanor of the first degree and the second degree. The first degree, the man can go to prison and let's say go to jail for 30 days, for 6 weeks, for 6 months, 9 months, 1 year, but not more than 1 year. That first degree misdemeanor. Second degree, not more than 30 days in jail. Then the second kind of classification is felony under Liberian law. And that happens also in Great United States. They have categories like this too. They get misdemeanor, they get felony. Now, under Liberian law in particular, you have crimes. These are crimes that are serious in nature and defined by the criminal law as very serious. Any crime where the incarceration is more than 1 year, it is a felony. Let me say that again. Any crime that is committed for which the person will serve the incarceration period of more than a year is a felony. Under Liberian law, we have categories of felony. We have first degree felony, we have second degree felony, and we have third degree felony. First degree felony, the category of crimes that fall under first degree can be capital offenses, can also be, sometimes you say life imprisonment, they can fall under that category. Punishment by death, that first degree felony. Some of the crimes where the term of imprisonment is more than 1 year where 1 year is more than 1 year is authorized. But again, when they say the imprisonment where the specification is that the maximum of 10 years in definition, that's first degree felony. Death, life imprisonment, or the maximum is 10 years imprisonment. They fall under the category of first degree felony. If you want to research that, you can find this in the new penal law. I put all of the references there for you to make your research also. That is what it is. That is what it's all about. In academia, when you provide the material, you give the sources. And so the students can go after the sources to make sure they confirm what is being told by the person teaching. Now, the second degree felony has to do with the imprisonment where the maximum will be 5 years. 5 years. You can't go more than 5 years. No judge has the authority to sentence a person to prison for a second degree felony that will be for more than 5 years. No. If the crime is a second degree felony and the judge sentenced the person to 7 years imprisonment when it is a second degree felony, the action of the judge is ultra-virus. In other words, it means it is outside the ambit of the law. He is acting outside the rule of law. He is acting outside the authority given to him by law. That's what it means. octroi virus. Then you get third-degree felony. Third-degree felony under Liberian law, the maximum is 3 years. If a man committed offense, so the judge can sentence you to 3 years imprisonment if you commit third-degree felony. He can sentence you to 2 years imprisonment for third degree, 1 year imprisonment, 6 months imprisonment, 30 days imprisonment. It is his discretion. They say maximum 3 years. He cannot go beyond 3 years. That is the discretionary authority that the criminal law, the penal code, and the criminal procedure law gave to the judge, the criminal court judge, the court of competent jurisdiction, not any other court, not any court, but a court of competent jurisdiction. Because all of the courts have specific jurisdictions. They can't just do certain things. For example, if it is a theft-related matter, for example, the criminal code C, like Monserrato County now, is the one that has the authority to sentence the person for theft. The criminal code A for Monserrato County has no authority to sentence somebody for theft-related offenses. That's why we talk about jurisdiction. Okay? So all of them have their own jurisdiction. Then we go to the next slide. Arrest. This issue of arrest. Sometimes we hear people say, "Oh, the police cannot arrest me without a warrant. With no warrant, I will not go." No, it's not true. But you, as a criminal justice practitioner, you know that the police, the law enforcement agency, has the authority to arrest without a warrant. They can arrest when you committed a crime in their presence. They can also arrest based on information that comes to them. That, look, this man has committed the offense and he needs to be arrested. The police can arrest you on that. We call that probable cause. But the first thing we need to do is we need to understand what is the definition of arrest. Arrest is the taking into custody of a person to answer questions. To answer questions regarding the commission of a criminal offense. That's what they call arrest. When a man is arrested, it means he is taken into custody in order to answer to questions regarding his violations. That's what we call arrest. And you will find that definition of arrest in the criminal procedure law. You see the law citations are there. You find that in volume 1, title 2, chapter 10 of the criminal procedural law, section 1A, and the law was passed in 1973. So when you see somebody or when you forcefully restrain a person by the legal authority, it is not, they are not saying you just see somebody, you don't have the authority. By legal authority, meaning the person must have committed an offense. Don't say, my man, you're looking suspicious. We're arresting you based on suspicion. The man looks suspicious. That's why we're arresting the man. We'll come to that. That one's a different ballgame. There are fundamental requirements when it comes to suspicion. And so it's not the basis for arrest. The arrest must be lawful. But you're taking the person into custody. You must have the authority to do so. Or the law gives you that authority. That's why we call it arrest. Now, under what condition can a person be arrested? The first condition that a person can be arrested is a warrant. The question is, what is a warrant? A warrant is an order from court that authorizes a peaceful officer to take into custody a particular person who have been accused of a crime and must be brought before the court of competent jurisdiction to answer to the question regarding the allegation of the commission of an offense. That's what we call the warrant. The next condition under which somebody can be arrested in the absence of a warrant. Sometimes they can be arrested when there is no warrant from court. We call that probable cause. And the question is, what is probable cause? Probable cause means those facts, those circumstances that are known to a reasonable law enforcement officer that a crime has been committed and that the person to be arrested committed the offense, and that there is evidence to believe that he committed the crime. That's what we call probable cause. Let me give you one example. You went to the police station. You went bleeding to the police officer. He said, John Brown slapped me or punched me. He caught me. I came to leave the man complaint. That police officer has reasonable ground to believe that a crime has been committed because he saw you bleeding, and that you have accused a particular person. And so there exists what we call a probable cause to effect an arrest. So you can say, oh, officer, I am not going because there is no warrant. No, not true. You can be arrested. The next thing you say, oh, in the net, I'm not going because in the net. That's not true. You can still be arrested when there is probable cause to believe that you have committed an offense, especially a felony. The next requirement under which a law enforcement officer can effect an arrest is called the plain view doctrine, or the plain view. What is plain view? Plain view means when the officer is looking, he saw you committing the crime. You committed the crime in plain view, so he can arrest you. Or the officer hear you committing the crime. How does a police officer hear you committing an offense? He hears you committing an offense in the following way. For example, he stands outside the building. He hears a woman crying, the man raping me, oh. For example, he hears the crime. That's what we call plain view. Any eye that can be perceived by the senses. When they say the senses, it's not only the eyes, the five senses. We call a plain view. He can smell the crime. How does he smell the crime? The police officer can smell the crime when he stands outside your window and he smells you smoking marijuana. Sometimes we can call it opium, but it's not really opium. It's marijuana. It's an hallucinogen drug. Opium is different from marijuana. But anyway, librarians, we can just, in our lingua franca, we can just say that opium. Opiate is from, it's not marijuana per se, but let us deal with it because we come to the technical era of using that. I want that drugs abuse. So, when the officer smells you smoking, he smells the smoke, he smells the cocaine, He smells a joint being smoked. Somebody getting high. So now call it ganja. They may taking a ganja. He smells it. He can move in there and bust that door and have you arrested because the crime was committed in his presence. That's what we call plain view. He doesn't need to go for a search warrant. Let's go to our last slide for the day. The elements of the petition for the search warrant. You know, search warrant is something you don't just go to the court and the court order and issue orders and issues it. No. The search warrant, in order for the court, the magisterial court, to issue a search warrant, there must first of all be a petition. There must first of all be what we call a petition. What is a petition? A petition is an application to the court by the city solicitor or the prosecutor of government. In Monroe, if it is in Monserrate, it is the county attorney or the city solicitor who is assigned in a particular magisterial court. He makes an application to the court, and that application must have and meet certain criteria. First, it must either be addressed to the justice of the peace or the magistrate. You know, the two of them get almost concurrent jurisdiction, justice of the peace and the magisterial court. When the petition is addressed to the magisterial court or the justice of the peace court, in that petition, the prosecutor who is asking for the search warrant may be asking for the DEA to go and search somewhere, or the police, LMP, to go and search somewhere, or the NSA to go and search somewhere. That petition must state the name of the place to be searched. That's the second requirement. The petition asking for the magistrate court to issue a search warrant. That petition must state specifically the particular area that the search will be conducted. And when the petition states that, the petition must also describe the items that are to be searched. The items that you're going to look for or to be seized during the search, they must be stated. The most important thing, which is not the least yet, is that court, that the petitioner, meaning the justice ministry or the prosecutor is making the application, that court must have jurisdiction. When we say jurisdiction, it means it must have the authority given to it by law to exercise that power. If the magistrate court or the justice of the peace court does not have the authority to issue the warrant, anything that comes out of that warrant is illegal. What does that mean? Let me explain that. If, for example, the Monrovia City Court issues a search warrant based on an application by the prosecution to go and search somewhere in Garnetsville or in Crucial Island, the Monrovia City Court lacks jurisdiction because the Monrovia City Court jurisdiction is only for Monrovia, stopping to Mecklin, Nipple Street area there. It does not go beyond Happy Home. No. That West Point Magisterial Court jurisdiction. The City Court jurisdiction does not go beyond Oro. That is to say, to go like places like Pinsville. If it issues a warrant for a search and seizure for a particular area in Peaceville, then the court, the magisterial court or the justice of the peace court has no jurisdiction over that place. That's what we call territorial jurisdiction. Territorial jurisdiction, meaning that particular territory, the court does not have that jurisdiction. The next thing about the petition asking the magistrate court or the justice of the peace court for the search warrant is that there must be an affidavit. Sometimes we call it affidavit. Some people say affidavit. So there must be an affidavit or affidavit. What is an affidavit? It must be attached to the petition. An affidavit is a sworn statement. You go and you take, you say, what I'm about to tell you, Your Honor, justice of the peace, is nothing but the truth. Everything I'm saying here is true, so help me God, based on that petition. Then you sign it, then the JP stamp it. You say now you have taken oath that everything in the petition is true. If it is not true, you lie under oath. That's perjury. So the law requires that there must be a sworn statement before an officer of the court or a justice of the peace. That's what we call affidavit or affidavit. The next requirement, element of the petition for the search and seizure, is that it must be signed by the lawyer making the application. The lawyer who is making the application must sign it. That lawyer must sign the application. If he doesn't sign it and he doesn't sign the affidavit, then obviously that particular petition, even when that rate comes out, they can move to strike it. That the petition that sought the issuance of the writ of search and seizure or the warrant was defective. So these are the requirements. The next requirement is that the element is that the petition must establish probable cause for the issuance of the writ of search and seizure. The warrant must state categorically that there is an offense that is being committed or that have been committed. And it must show and convince the magistrate or the justice of the peace that there exists evidence to believe what the prosecutor is saying. That's what we call the petition must establish a probable cause. So let us stop there today. We stay on section 1 because that is introduction to criminal justice. Section 2 will be criminal law. Criminal law will be Thursday. Tuesday is introduction to criminal justice until we can finish the course. And then Thursday is criminal law. That is for students who are third-year students in criminal justice or law school students, those who are in the law school, who have interest in criminal law or maybe doing it next semester, or they come in opening semester, or who have done it and maybe they want to sharpen their knowledge also with the subject, then they can choose Thursday. Thursday is criminal law. Thank you for listening. Thank you for coming. And I'd like to say, admonish you, I'd like to welcome you to this page. You can go to the YouTube page and subscribe, because as time goes by, that is specifically where my focus will be. That is specifically where, because that is where you will be accessing the materials from me, not on the Facebook page. It will be on the YouTube page. So please go on the YouTube page and start subscribing. For now, what we're doing is free knowledge. Maybe in the future, when the time comes, there are certain courses, maybe we have to be discussing the issue of other things. But for now, I like to make sure to give I give back to society, to encourage my students, to encourage other young librarians coming up to develop interest in this particular profession as a career, to have love, to decide to focus and maybe identify a career in the area of criminal justice or criminal law or law as a profession. Thank you for listening. I appreciate you. For most of my students, I see most of you coming on. Thanks for coming. listening. I can see I see Ola Jacobs, Aliyu V. Kumar, Nixon V. Masa Sion, Roberta Blessing Bola, Agnes Fekide. I see Aaron Zien, Seka Rav Kofan. Okay, this is one of my former students. The guy has a criminal justice degree. One of my strong boys. John Don Toll Jr., Chris H. Harris. Yeah, Chris Harris. Johnson Obidelia, Mohammed Skamara, Eskamara, no Skamara, yes. Aziaga Sua, Ambassador Daniel E. Zawi Jr., D. Emmanuel Munzer, Kev, Sedo Masale Alfonso, Joel Do, and many others. So you can focus on the YouTube. You can try to subscribe to the YouTube because that is where you might likely be accessing the materials. Once we're completing the course, we'll be giving the material free of charge. We'll be giving you the materials so you can use them for yourself. Thank you, Brown Richards. Yeah, thank you. I appreciate it. Thanks for coming. Simply, Dukley, Rare, Continue Hodge, you guys are welcome. Thanks for coming. So you can follow the Facebook page. Thank you very much again. Tomorrow, Wednesday, Thursday will be Criminal Law 100. Have a good day. Thank you.